Y'all got real quiet.
My name is Mary Grace Clarkson, and I'm a Royal representative for Mao's Federalist Society chapter. On behalf of our team, I'd like to thank everyone for joining today's discussion of whether plea bargains are coercive, especially our speakers, Professor Coercive of the University of North Carolina School of Law, and Decatur County Prosecutor Nate Carter. Professor Hessick joined the Carolina Law faculty in 2016. She serves as the Anne Shea Ranzel and William Garland Buck Ranzel Jr. Distinguished Professor of Law and as the director of the Prosecutors Analysis Project, which she founded in 2018. Her teaching and research interests include criminal law, the structure of the criminal justice system, and criminal sentencing. Professor Hessick's work has appeared in distinguished publications such as the Cornell Law Review, Virginia Law Review, and LA Times. She currently serves as a reporter for the ABA Criminal Justice Section's Sentencing Standards Task Force. Professor Hessick attended Yale Law School, where she was an editor of the Yale Law Journal and winner of the Potter Stewart Prize for the Morris Tyler Moot Court Appeals. After graduating, she clerked for Judge Barbara Jones on the Southern District of New York and for Judge Raymond Randolph on the DC Circuit. She also worked as a litigation associate at Wachtell Lipton, Rosen & Katz in New York State. Previously, Professor Hessick taught at Arizona State Sandra Day O'Connor College of Law and the University of Utah's Quinlan College of Law. She also spent 2 years as a Commando Fellow at Harvard Law School. Mr. Harder was raised in Decatur County and attended Butler University on Lilly Scholarship, which recognized his dedication to building a career for a future return to Decatur County. After graduating Butler in 2010, Mr. Harder enrolled at the Maurer School of Law, where, among other extracurriculars, he was a Sherman Moot Court champion and Federalist Society president. After graduating from Maurer in 2013, he was elected Decatur County Prosecutor in 2014 at the age of 26. He still serves this office today, combating substance abuse, property crime, and domestic violence. As prosecutor, he's won nearly 90% of jury trials and instituted new policies to protect vulnerable victims. Mr. Harder sits on the Indiana Prosecuting Attorney Council's Legislative Committee and the Board of the Association of Indiana Prosecuting Attorneys. He's also serving his second term as chairman of the Decatur County Republican Party. He's active in Greensburg's community, where he lives with his wife and young son. As we begin, I'd like to remind everyone to please adhere to COVID protocol throughout this event, and please join me in welcoming our speakers.
So thank you all so much for coming out today. When I was in law school, I really appreciated the fact that the Federalist Society made an effort to bring in people to talk about important issues, made an effort to get people with opposing views to not just air those views, but to really engage on the substance of important questions. And so I was incredibly flattered that FedSoc here at Indiana thought that my book could serve as a platform for such a discussion. I will say that although I really appreciated that character of FedSoc when I was in law school, as I went out into the world as a practicing attorney, I found that the FedSoc events that weren't aimed at law students didn't have that same character, and that FedSoc as an organization seemed more committed to partisanship than to ideas. And so I would just make a plea to all of you who are in FedSoc right now, if you decide to graduate and continue on with the organization, to make an effort to carry the ethic that you guys have here while in law school to the organization outside of the walls. I think the country needs more substantive discussions. Don't think that they need more partisan organizations. That's just me, but I hope you agree and that you'll do something there. That aside, here's what I want to do today. I was hoping that I could read an excerpt to everyone from the book that I wrote on plea bargaining. The book is not just supposed to be for academics or even for lawyers. It's also supposed to be for the general public. And so what I tried to do was use stories to talk about plea bargaining, the problems with it, and why we should all care. And then after I read the excerpt, I'll talk a little bit more about plea bargaining and why I'm so excited to be sharing the stage today with Mr. Harder. Okay. Chapter 3, it's a business decision. Harry owned a small business that depended on investment. When the bottom fell out of the US economy in 2009, some of his investors lost money. One of those investors was friendly with an official at the Securities and Exchange Commission, the federal agency that regulates the stock market and other investment activities. After that investor complained to his friend, the SEC raided Harry's companies over a holiday weekend, taking all of the company's computers and records, and those computers and records still to this day haven't been returned. In addition to the SEC investigation, Harry and his partners were charged with fraud. Federal prosecutors threatened Harry and his partners with more than 200 years in prison. All of Harry's money had been seized by the government, and so he had to borrow money to hire a lawyer. Harry explained to his lawyer that he didn't do anything wrong. He didn't defraud any of his investors. It was just bad luck. Harry's lawyer talked to the prosecutors, but the prosecutors were only willing to offer a plea deal of 20 years in prison. So Harry and his partners decided to go to trial. As the trial date got closer, the prosecution started to offer better plea deals. Harry and his partners kept insisting they hadn't done anything wrong. They'd followed all of the SEC rules and they hadn't defrauded anyone. So they wanted to tell a jury what happened. But their lawyer said that might not matter. He said that the jury wasn't going to understand the SEC rules. He'd seen juries who thought the defendants were probably innocent, but then they convicted on one count of an indictment just in case. The lawyer explained to Harry that if the jury convicted on even one small count, he was still in big trouble. Even if you're acquitted of one crime, federal law allows judges to give you a higher sentence if they think you probably committed other crimes. For example, imagine a prosecutor charges you with burglary and with murder. The jury acquits you of murder, but they find you guilty of the burglary. If the prosecutor convinces the judge that most of the evidence suggests you actually were guilty of the murder, then the judge will give you a very high sentence, probably the highest allowed by law on the burglary charge. Even though you won at trial, you'd lose at sentencing. Harry knew that if the jury acquitted him of most charges, the judge would probably give him the maximum punishment or close to it on any charges for which he was convicted. But he and his partners still wanted to go to trial. He knew that he was innocent, and as he put it, lawyers spend their lives convincing people to plead guilty. Those are his words. Harry's lawyer understood that his clients thought they were innocent, but he couldn't understand why they were insisting on going to trial rather than just trying to negotiate the best plea deal possible. At some point, the lawyer was yelling at us, telling us we were ruining our lives, Harry recounted. This isn't about guilt or innocence, the lawyer told them. It's a business decision. Finally, the prosecutors offered a deal that Harry felt he couldn't refuse. Although they had initially insisted that Harry serve 15 or 20 years in prison, when it became clear that Harry was willing to go to trial, the prosecutors offered him a much better deal, only 2 years. Harry's resolve to take his case to trial began to waver. You dream of going to trial and winning, Harry said, but what do you really win? You win your innocence, but in a lot of ways you still lose. And if you lose at trial, then you leave your family with nothing. Even though he still adamantly believed that he was innocent of any wrongdoing, Harry accepted the plea deal. He had a good lawyer, he had a good case. His lawyer didn't even think that the things Harry had done were actually illegal. But Harry realized the inevitable. The deal was too good to pass up. Talking to Harry, I can't say that he made the wrong decision. Based on the charges that the prosecutors brought, Harry was facing up to 200 years in prison if he was convicted at trial. It's doubtful that a federal judge would have imposed a sentence that high, but it was quite plausible that the judge would have imposed a sentence of 20 or 30 years if Harry had been convicted after a trial. So it actually would have been irrational for Harry to have turned down the plea offer of only 2 years. Now, when I say it would have been irrational for Harry to turn down the plea offer, I literally mean that no rational person would have turned down that offer. The math just doesn't add up. Now, it might sound strange, but we can actually use math to assess whether a defendant's decision to plead guilty is rational. We do this by calculating what economists call the expected punishment. So you can calculate the expected punishment by multiplying the punishment that the person would receive if they're convicted at trial by the probability that they would actually be convicted. So for example, if I've been charged with a crime that carries a 10-year sentence, and there's a 50% chance that I'll be convicted at trial, then my expected punishment is 5 years, right? So 10 times 50%, which is really 0.5. So you get 5. Okay, good. I know it's math. It's math. That's why I used those numbers. Okay. So if a prosecutor offers me a plea bargain that would require me to serve less than 5 years in prison, then I should take the deal. Now, the idea of calculating expected punishment might seem crazy. After all, if I'm acquitted at trial, then I'll spend 0 time in prison. In accepting a plea deal, I give up my chance at acquittal. But at the same time that I've given up my chance at acquittal, I've also limited my risk of spending more time in prison if I'm convicted at trial. So the idea of expected punishment treats going to trial as a gamble. You might win big or you might lose big, and the plea bargain allows you to hedge your bets. And calculating the expected punishment lets us evaluate whether that plea deal is a better bet than the gamble of going to trial. An expected value calculation tells us that Harry would have been irrational to turn down the plea deal. Let's assume Harry was facing a 20-year sentence if convicted at trial, and he may have been facing more, but let's just say 20. The plea deal required Harry to spend 2 years in prison. 2 years is only 10% of 20 years. So even if Harry thought that there was an 89% chance that he'd be acquitted at trial, it was still rational of him to take the plea deal. The deal allowed him to hedge his bet, and it was less than the expected punishment. Now, everybody in the criminal justice system knows that plea bargains are about defendants hedging their bets. If a prosecutor offers a good enough deal, a plea bargain with a sentence that's significantly less than the expected punishment, then a defendant would have to be crazy to turn it down. And that's actually what everybody thought about Joseph Tigano. They literally thought he was crazy because he turned down a plea deal and insisted on going to trial. Joseph Tigano and his father were arrested for growing more than 1,000 marijuana plants in their farm on upstate New York. Joseph's father pleaded guilty to a lesser crime, manufacturing 50 or more marijuana plants, but Joseph refused to plead. He sat in jail for more than 9 months waiting for a trial, and when his lawyer postponed a court date without telling him, Joseph went on a hunger strike. The defense attorney responded by asking the judge to order a competency evaluation, right? A mental health screening to see whether Joseph was mentally capable of standing trial. The lawyer's request to the judge and the judge's decision to order the competency evaluation were based in part on Joseph's insistence that he receive a trial and his complaints that the trial hadn't taken place yet. The competency evaluation came back. Joseph was competent to stand trial. Now, because his lawyer wasn't respecting his wishes about scheduling the trial right away, Joseph asked the judge to let him serve as his own lawyer. Proceed pro se. You guys know these words. Not everybody does. The judge eventually granted Joseph's request, but insisted on appointing a new lawyer to serve as Joseph's standby counsel, right? Someone who would come to court for all of the court dates and help Joseph if necessary. This second lawyer also thought that Joseph's insistence that he wanted his trial to take place right away was incredibly strange. And so she suggested another competency hearing, which also found that there was nothing wrong with Joseph's mental abilities. Despite his repeated pleas to hold trial, Joseph sat in jail for years after that second competency evaluation. One reason for the delay was that the lawyers were trying to negotiate a plea bargain. Another reason was that the government had failed to hand over some documents to Joseph and his lawyer. Crowded court dockets also contributed to the delay. And throughout this long delay, Joseph kept telling the attorney who was helping him that he wanted to go to trial. He wanted to go to trial right then. And the attorney responded by filing a confidential motion with the judge recommending a third competency evaluation, saying that in refusing to plead guilty and insisting on his right to trial, Joseph was acting, quote, imprudently and not in his best interests. The prosecutor agreed that Joseph should have another competency evaluation, not because the prosecutor thought that Joseph was actually incompetent to stand trial, but because he thought there might be, quote, some other psychological problem that's going to prevent him from understanding the difference between what he potentially looks at as far as a conviction, as well as what's being offered by way of this plea. In other words, the prosecutor thought that something must be mentally wrong with Joseph because he didn't seem to understand that the plea deal he was being offered was much better than what would happen if he went to trial. After sitting in jail for nearly 7 years, Joseph finally got his trial. He was convicted, but he later got that conviction reversed because forcing him to wait that long for a trial violated his constitutional right to a speedy trial. So the Second Circuit reversed and Joseph got out. Now, like Harry, Joseph was facing a much lower sentence by pleading guilty rather than going to trial. After he was convicted at trial, Joseph was sentenced to 20 years in prison, and his father, in contrast, who was arrested the same time as Joseph for the identical crime, pleaded guilty in return for a sentence of time served. And at that point, he and Joseph had sat in jail for 4 years. Now, it's no wonder that Joseph's lawyer, the prosecutor, and the judge all thought Joseph was crazy. If he'd pleaded guilty, Joseph would have only spent 4 years in jail. And by going to trial, he was risking another 16 years in prison. Like the 200-year maximum sentence that Harry was facing, the 20-year sentence that Joseph was facing allowed prosecutors to place a lot of pressure on him. The higher the sentence prosecutors can threaten, the more it changes the expected punishment calculation in their favor. If I'm facing 100 years in prison, if I'm convicted, then I'm going to jump at a plea deal of only 1 year. But if I'm facing only 3 years if I'm convicted, then the 1-year deal doesn't seem like that good. In other words, the longer the sentences, the more leverage prosecutors have in plea bargaining. How did prosecutors get this leverage? Well, they got a lot of help from legislators. Now, the rest of that chapter talks about how it is that we've sort of ended up in the system that we have, where expected punishments are so high and the pressure to plead is so overwhelming. It talks about mandatory minimum sentences. It talks about sort of the continuous cycle that we see in state houses and Congress to constantly enact new laws for new crimes and to increase punishments. But it doesn't just talk about that cycle. It also points to examples of lawmakers saying that they're increasing these sentences because they want prosecutors to have leverage to have people plead guilty. There's a specific example in the book involving Senator Chuck Grassley, where when there was a push to reduce the mandatory minimums for drug crimes because the amounts just aren't that high, and so people who aren't that culpable get charged with these crimes, Senator Grassley pointed to data from the US Sentencing Commission to say that most people charged with these crimes plead guilty to something else, and that's the way the system is supposed to work. Now, I also talk about the fact that judges are not the hero in this story. You know, their historic practice of imposing a trial penalty, so very high sentences on people who insisted on going to trial rather than pleading guilty, probably created the plea bargaining system that we have today that's so prominent. It also talks about their failure to impose constitutional limits on plea bargaining, which I'd be happy to talk more about in the Q&A. But one important limit that they've failed to place on it is they've failed to place limits on what prosecutors are allowed to say that defendants must agree to in the plea deal. A plea deal doesn't have to be limited to, I agree to give up my right to a jury trial. It can also include things like discovery. It can include the right to an appeal or the right to habeas relief. It can include the rights to any civil claims if there was police or government misconduct. It can even include disposing of criminal charges, potential criminal charges against people's family members. We saw this in the Michael Flynn case, where Michael Flynn agreed to plead guilty, and part of the written plea agreement was that the government wouldn't pursue charges against his son. All of this contributes to the leverage that I'm talking about and makes it even more lopsided. That said, I'm not the only person that you guys have come here to listen to today. I'm so excited that FedSoc also invited Nate Harder, who is an elected prosecutor. And I have to say, as somebody who literally studies elected prosecutors, I could not be more excited. I'm going to be taking copious notes as he talks, not just because it's sort of like a research moment for me, but also because when I found out that Mr. Harder was going to be here, I did what any sensible person would do, which is I Googled him. And I found a news story from his hometown paper, the Greensburg Daily News, where when he announced that he was running for re-election in the 2018 election cycle, he spoke about his accomplishments in his previous term as prosecutor, and he specifically talked about plea bargaining. He said, he touted as an achievement that his office has had more jury trials than in the past, that he doesn't use the leverage that's been given to him in the form of recidivism statutes to pressure people into pleas. He just charges people with that and sends them to jail for the long time that is said. He's also touted the fact that he's had a really large increase in the number of charges that he brings in his community, that there was an increase in 40% of charges. And I know he has lots of other things that he wants to talk about, but I am very curious to hear how a community of approximately 27,000 people has 1,400 criminal charges brought in a single year, because either a small group of people are racking up a lot of charges or more than 5% of his neighbors are under indictment. So, but I'll stop there and let Mr. Hart-Tom speak for himself.
Well, thank you very much. And thank you to the Federalist Society chapter here at Indiana Maurer. It's good to be back home in front of a chapter that I ran when I was here. I want to make sure before I get too far down this road that similar to how in an introductory statement in front of a jury trial, where part of my job is to manage the expectations of the jury by saying, here's what you will hear today, here's what you will not hear today, and then not surprising them. It's important for me to set expectations for you all here today. And I just want to go back in case you didn't hear in the introductions. The person I'm discussing with today was the national champion of the American Parliamentary Debate Association when she was at Columbia, was best written and oral argument in the moot court competition at Yale, was the Yale Law Journal editor, went on to clerk for a federal judge, worked in a tall building in New York City, and joined the professoriate. So,
but that's okay, because my 7-year-old can still beat me in an argument.
So whereas I am a simple and lowly Maurer grad who is working in the countryside to try to humbly ply my trade. And so having set the bar appropriately low, let's go from there. It is a strange feeling for me to be the counterpoint in a Federalist Society event, considering how much I have found myself identifying with the values that the Federalist Society puts forward and how much I value the ideas that this organization put forward when I was here. And I'm happy to report that the Indianapolis chapter of the Federalist Society still does, as opposed to partisanship, as a practitioner now. And so the idea of exploring from a 100,000-foot view, really, the work that I do and seeing it from the perspective of someone who has made their life's work studying and suggesting improvements for how to do better what I do on a day-to-day basis was a nice reprieve from drafting motions to revoke bail and reviewing charges and interviewing victims or dealing with angry mothers. And this was a really neat exercise for me. And I took the time to read your book and took notes along the way. And I came into it, I confess, when I first got the prompt, I was like, oh goodness, to remove plea deals from the equation and go solely to trials. I love a good trial. I think they're critical parts of what we do. How is this a real suggestion? But if this is someone Federalist Society is bringing in, then they're going to have a lot of the same values I do, a lot of the same end goals that I do. And if they're studying it from 100,000 feet across the country, I'm looking forward to some of the best practices that maybe I could adopt in my own right, and maybe challenge my own thinking about how I address sentencing decisions along the way. The good news is that there's a lot that we agree on and a lot of common goals. There are things about that we'll get into where we disagree, as you might imagine. Otherwise, this is a very boring conversation. But primary among these, I think we have a desire to treat defendants as real life human beings who have real stories to tell, not just a file to be closed, not just a statistic to put into a re-election speech. And so I have tried to make a practice in my office of adopting procedures and mechanisms by which we can arrive at the truth as often as possible. And one of the places that I hope we can discuss sort of a difference of opinion, or maybe can reconcile some first principles. I'm not sure I accept the premise that efficiency necessarily is mutually exclusive to truth, or that trials are necessarily a better venue or vessel for just arriving at the truth. In a moment, I'm hoping to do a mock-up of how I sit down with defendants. I do mostly the major felonies. That's the prerogative of being the elected prosecutor, along with my chief deputy. We get the more serious cases. And with a great deal of frequency, the best way for us to resolve a case is to actually sit down and talk. And we can talk more about why that is. And what I find is that when I treat these people as human beings with inherent dignity, made in the image of God, with divine potential that is yet uncaptured in many cases. And I listen to what the truth is. Sometimes I go, no, I think you're full of crap and you need to go to jail for what you did. And sometimes I say, well, maybe you did something, but you didn't do this. And when I treat it as though I am actually interested in the truth, and when I demand that my deputies treat it as though they are seeking after truth and not just closing files, I think we get better results across the board. Having said that, part of what you'll hear me say during our mock-up here in a moment, I hope I don't talk too long, is that I suggest to the defendants in 99.999% of cases, I wasn't there when it happened. In fact, the police usually were not there when it happened. So we see the truth of what happened through a peephole. And so we think we know, we make the best decision we can, armed with the information that we have. We can't be frozen into indecision by the fact that we don't have everything. We have to make some kind of decision to make the best decision we can and still sleep at night, being able to look in the mirror, knowing that we did the best we could. And so I invite defendants to fill me in. I have a lot of other things I want to talk about in the book, but I would like to ask for a volunteer to come play the defendant. I don't need much from you, and this is one of the first rules of cross-examination is don't ask a question you don't know the answer to, because you don't know what will happen. But if one of you will volunteer and promise not to intentionally mess me up, why don't you come on down? And for these purposes, I'm vaccinated. I don't care if you sit right there and take the mask off, because now you're presenting too. Here, why don't you sit right here? I think I'm loud enough that you guys can still hear me if I sit here. Okay, what's your name?
Raul De La Rosa.
Raul De La Rosa?
Yes.
Okay, Raul, is it okay if I call you Raul?
Sure.
All right. Raul, thank you so much for being here today, here in my office. I see that you're wearing oranges and handcuffs, and you're here with your attorney. And I appreciate you coming to talk to me. I hope you understand you don't have to talk to me. But, you know, I'm a law enforcement officer. I carry a badge and I carry a gun. And if I were encountering you on the street, clearly you're in custody. I would have to advise you that anything you would say could be used against you in a court of law. I would have to advise you have the right to remain silent. Clearly you have the right to an attorney. You have all those rights and you don't have to talk to me. But I'm hoping that as we sit here today, we can go past the normal process and get to clarity faster. Normally what would happen is I would send discovery materials to your attorney, the body camera, the police reports, lab results, and then I would eventually send a plea proposal to your attorney, who would then eventually get to the jail to see you. You would think about it, talk to the attorney about it, talk to your family members, give them an answer. Eventually they would bring your answer back to me. And this would go back and forth and probably take weeks, probably take months to get done. And my hope that is, if we can sit here and I can explain to you the evidence I think I have and why I've offered the plea deal I have, that you can understand where I'm coming from. And I'm hopeful that you might be willing to talk to me about what I misunderstand, information I don't have that might give me a better picture of what justice looks like, why the sentence I've suggested doesn't make sense. And what I can assure you, you have two protections. One, our rules of evidence say anything you say in here is a statement made in search of a negotiated resolution. I couldn't use what you say in here against you. The other thing is I waive my rights to use what you say in here against you, because I'm interested in cutting through the bold stuff and actually getting to a result that closely resembles the truth of what happened and is something close to justice. The chances are really good neither of us is going to get exactly what we want, but maybe we can find something that makes sense and looks like justice. If not, no harm, no foul. You're not going to be worse situated because you walk away today. But if we have to go to trial, that's what we do. That's part of how the system works. Is that a discussion you'd be interested in having with me? Sure. Okay. If I give you all the information I have, and I may have to be firm with you in expressing why I believe what I believe, but I try not to treat you with disrespect. Can you promise to be candid with me about how you feel and what you think might be able to be done today?
Definitely. I will tell you what I feel and what I would like to get out of this communication.
Okay. If we can get something done, I understand that you've been sitting there for a long time and you want to be done. I'm interested in getting clarity for you and for my victim in this case. So let's in good faith see what we can get discussed. Does that work?
Absolutely.
Okay.
And here's a motion for a speedy trial.
That's fine. The state will be ready to proceed. Okay. So we could go through the whole thing. We don't have time for that. But that is a fairly standard opening colloquy for me. Then I would turn to the defense counsel and say, we've done this before. Thank you so much. A round of applause for all of the hard work and acting ingenuity of Raul. Okay. So I know I didn't ask much of you there, but I appreciate you being willing. One of the things that I frequently say to defendants is that they know better than I do what happened at the time that the police were called. And that they can measure even better than I can what their potential risk is of being convicted because they know whether they did it or not. And that they should talk to their attorneys about measuring the evidence that I have and the risk of the jury believing it. But here's my estimation of why I believe I can convict on this or I can't convict on that. We have found those discussions to be immensely productive. I can give one example, and here another thing that I will mention. Professor Hessick mentioned using stories to make a point. And on the one hand, the plural of anecdotes is not data, but on the other hand, they are compelling. And I'm hopeful that by sharing some anecdotes of my own, perhaps we can continue the discussion in evolving perspectives on how law is being practiced and how criminal justice is being done outside of some of the major metropolitan jurisdictions and some places that maybe haven't had as much study paid to them. An example recently that I can point to, it's all resolved, so I can talk about it. We had 3 young African-American males from Louisville drive up to Greensburg to buy dabs, marijuana wax cartridges. It was cheaper in Greensburg, and the margins, they had done their business study, their business plan. It was cheaper to drive to Greensburg and buy from our guy than it was to buy in Louisville. So they were coming up to buy and then driving back to Louisville. All I knew was they were coming to buy weed. And we got a call to the apartment where the drug dealer lived of a robbery. That 3 armed black men had broken into the apartment. They had taken weed and other things. They had a gun, and then they fled when a neighbor tried to intervene. A manhunt ensued. We got everybody tied up and put in jail. And the facts that I had available to me, coming from a known drug dealer and his wife and their 2-year-old kid, not that he said much, was that this had happened the way they described. That's what I had. Oh, and the neighbor who came over and said, I saw 3 armed black men running out of this apartment. They had the wallet on one of them had the wallet on him when he was gone. I was like, this is what the evidence shows me. Eventually we had one of these proffer sessions where they explained to me we were coming up to buy. We were attempting to possess marijuana. We were attempting to buy it in order to sell it. We were not coming to rob anybody. While we were there, we came armed because we were coming to rural white America right after Breonna Taylor. We're from Louisville. We came armed. While we were there, this drug dealer started dropping N-bombs. And we told him, hey man, that's not cool. And he said, it's my apartment, I can do whatever I want, and continued. And at that point, the fight was on. And a fight broke out, and because a fight broke out, guns started being drawn. They fled, took his wallet for their trouble. I became persuaded that this was actually what had happened. And I measured what they had to tell me against the fact that my victim was a known drug dealer, and having known him for a very long time in our criminal justice system, said, yeah, that's what happened. And we pled their robbery case down to battery and theft instead of robbery, all probation, go back to Louisville, go on with your lives. The fact that they pled guilty to that, yes, had something to do with the fact that I had a robbery hanging over their heads. But it also was a reflection of the truth of what happened and taking responsibility for what happened. In the same way that in chapter 3, we are offended by these attorneys in the system telling the defendant, you're crazy for taking this plea deal. I think it is problematic for the opposite to not be true. That if defendants want to take responsibility and resolve their case and get to clarity, it's problematic to declare from on high that they're not permitted to, especially given that over and over again in the book, from the young man who pled guilty, and at the end of the book, you asked him, do you regret pleading guilty? He said, no, because if I gone to trial, they would have fried me. That's not quite quote, but
It was Western North Carolina, they would have fried him.
they may have. And even the most progressive prosecutors that you interviewed didn't see an increase in trials. And in fact, were flummoxed by, why would you ask me if we're having more trials? Why is that an appropriate metric for measuring whether we're being fair and being successful in administering justice? It occurs to me that throughout the book, there are accusations, accusation may be too harsh, although we're told that we're liars and colluding, so maybe accusation isn't too harsh, that judges and prosecutors and legislators and defense attorneys and juries are complicit in applying this pressure. At the same time, how can the proposed remedy be more trials if what everybody's afraid of is that jurors will then be more harsh? And I guess one of the questions I would want to ask is a twofold question in the same vein. Throughout the book, especially in chapter 4, I think, we talk about how the voters and the public don't understand and don't have a sufficient grasp of the criminal justice system to pass good laws regarding pretrial detention. They don't understand. If they were just educated better, they would understand that pretrial detention is a problem and we need to do away with it. But the very same people who are voters and don't understand and are not sophisticated enough to make those choices are literally the ones who serve on the juries. So we're relying on the same people, the same pool of people, and I'm hoping we can have that reconciled. And then secondarily, how could the remedy for the risk of trial provides too much pressure to have plea deals be fair, be let's do more trials, in addition to what I'm sure you get all the time, which is how do we pay for it? How do we actually do it? And that seemed like too low a fruit. So I don't want to go there necessarily. I would just say that it is consistent with American principles of jurisprudence going back to the founding that the criminal justice system should be administered swiftly and surely, and then people should be reintegrated. And I think that the swift administration of justice, more often than not, takes into account people taking responsibility for their actions and arriving at truth, that it does sometimes get abused. And many of these examples are egregious examples where somebody should be disciplined or lose their law license. But I'm not sure that what I've seen through the book and through chapter 9, Possibilities for Change, that there is a real push to get rid of plea deals, but rather to reforming them in a way that is kinder, gentler, and takes into account the needs of defendants as human beings. And I think far more of us are doing that than the anecdotes might suggest. I'll stop there.
Yeah, no, this is fabulous. So super, super, super thoughtful pushback and descriptions from someone who I think is actually doing some of the things that I recommend be done in my book. Now, the prosecutor that I spoke to who was doing these things was a self-identified progressive who'd been elected in the suburbs of Washington, D.C. But I hope you all agree with me that I think when we try to figure out how to solve complicated legal questions, these shouldn't be questions about, whether you have a D or an R behind your name on the ballot. It's a question of policy and a question of law. And I actually wish that I had interviewed Mr. Harder instead for the book, because that might have given a little bit more credibility to the idea that you can do these sorts of things without seeming as though what you really want to do is shrink the footprint of the criminal justice system.
Sequel.
Sounds good. So let me say a few quick things in response. I don't think we should abolish plea bargaining, as he just mentioned at the very end. Like, my recommendations are about how to try to reform the system. I don't think we should abolish plea bargaining because I think that it wouldn't work, among other reasons, but also because the way we've set up the system right now, if our first step would be to get rid of plea bargains, then what we would have is everyone spending forever in jail for these super long sentences that we have created in order to get people to plead guilty, not because we think that they are the appropriate sentence that someone should serve. I will say that I really appreciate the idea that, that a prosecutor sit down with the defendant and the defense attorney and have a conversation that's designed to get at the truth. That's not what you see in a lot of jurisdictions. You see, I think, what Mr. Harder is trying to push back against is this idea that it's about closing files rather than about getting to the truth. But let me say two things about his approach. The first is what we didn't hear him say to Mr. De La Rosa. We didn't hear him promise to tell Mr. De La Rosa all of the information that he had gathered in his investigation in the course of deciding to prosecute this case. What he was doing is he was telling Mr. De La Rosa that Mr. De La Rosa had to make a pitch to him so that he could make the decision, not putting Mr. De La Rosa necessarily in a better position in a negotiation, but just telling Mr. De La Rosa, you can tell me what you want and I'll take that into account when I make my decision. Because that's the second thing that I want to say about this process. I think it's great that Mr. Harder and his colleagues are trying to get at the truth, but who should be charged with that in a democratic society? The people who wrote our Constitution did not think that that should be government officials. They certainly didn't think it should be executive branch officials. They didn't even trust judges because, as Justice Scalia said in Blakely versus Washington, judges are also government officials. The right to a jury trial appears twice in the Constitution, in the body of the text, and then also in the Sixth Amendment. That's because the people who wrote this document thought that average people had to be involved in deciding whether people should face criminal punishment. They thought it was so important that that input occur on a case-by-case basis. And I take very seriously Mr. Harder's question. How is it that I can critique voters who vote for people who advocate for very harsh policies and then say that they'll act differently on a jury? And the answer is because people act differently when they're asked to make decisions in the abstract than when they're asked to make decisions in individual cases. There's actually really good social science evidence on this, that when you ask people questions about what punishment people who commit a burglary should receive, they give you a number, and then you give that same person the facts of a burglary, and they give you a lower number. That's because we're actually using different parts of our brain when we have to make complicated judgments about individuals than when we're asked to react to big picture questions. So that's what I think. I think, he and I disagree about a lot of other things, but I think that Justice Scalia was correct to talk about the jury as the circuit breaker of democracy. That it's not just that the people should have input into criminal justice policy at the wholesale level, but that they also then have to check how that policy is being implemented on the retail level as well in individual situations. That said, are trials going to fix everything? Of course not. People are still going to get things wrong. We haven't done a good job trying to reform the trial system, trying to ensure that there's, for example, sufficiently funded indigent defense. As for whether we can pay for it, Mr. Hartner is correct. We can't possibly pay to give a trial to every single person that we charge with a crime in this country. But maybe that should give us pause. First of all, there's some stuff in the book that actually shows we could give a lot more trials than we give right now. The number of federal criminal trials is like 25% right now than it was in 1990, even though we have more prosecutors and more federal judges. So we do have a lot more capacity than we use. But putting that to one side, we have 1 million felony cases filed in this country every year. We have 13 million misdemeanor cases. I think that if we revisited our decision to deal with so many social problems through the criminal justice system, we actually might be in a position where we didn't have to value efficiency that much. If we tried to solve problems through things other than convicting people, making them pay fines, maybe spend a couple of months in jail and instead try to get at root causes for those problems, or maybe just live with the fact that sometimes people make us angry and we shouldn't punish them for it. Then maybe we wouldn't have to say, we can't have 14 million trials a year. It's true, we probably can't. But we could have a lot more than we're having now. And maybe we should spend some time thinking about what we actually care about before we say people should be branded criminals for doing it.
Can I respond to that? Just that last bit.
Sir, reply, man.
So just so you know, in Indiana, one of the problems that one of the reasons you will get the reaction of Indiana prosecutors that you've gotten out of me is that we just had a major criminal code overhaul that was intended to separate those we're mad at from those we're scared of, and all of that rhetoric, with the idea that we would reimagine the paradigm and shift spending into dealing with the social pathologies and root causes of crime. And I am so totally on board with that. The reason that there's pushback, especially in Indiana, is that our legislature said, so what we're going to do is reduce all the penalties for everything, and local jails figure out how to provide those services. There was no funding for it. There was no structure for it. There was just put criminals back out on the streets. And that resulted overwhelmingly in more and more victim crimes. And we're seeing it right now in Indianapolis, where they're having something like 3 murders a day or something, 2 murders a day, far outpaces any record that we've had in forever. And I put it directly on the shoulders of those who put the cart before the horse. It would be easier for us to accept those baseline principles if it were accompanied by a serious effort to actually deal with those root causes. Because in the meantime, I've got real live people who are being victimized, and I have no recourse for them, at least before I had a jail cell for a couple of days to cool things off. That is a far cry from what I want, but I want people safe, and I would sacrifice that. We've been burned, and we'd like to see the other made first.
So I totally appreciate that. And I'll say just really, really quickly that I studied that justice reinvestment package along with prosecutor lobbying in all 50 states. And I have some questions about the positions that prosecutors took on some of those bills, because even though the state moved forward on that, there were some interesting patterns about what the prosecutors said that they would support and what they would oppose. And that support and opposition seems to, let's put it this way. If prosecutors had come out and said, instead of also give us all of this new habitual offender legislation, give us the funding to do these sorts of things, maybe that would have played out differently. I think we see prosecutors have a lot of clout in state. We put a report out on this in June. Happy to talk to you about it until you really don't want to hear any more about it. But I'd say that you guys are sophisticated operators. I know you're part of IPAC, and you guys have your lobbying agenda and those sorts of things. Since you're part of that organization, I would say, like, I agree with you. You should go back and you should say, like, these are the interventions that we think will make a difference and stop truly violent crime. Those places where they've done the data analysis of where the shootings have gone up and stuff like that, I'd be shocked if the taking away the ability to put someone in jail for a few days is what led to the spike in homicides and shootings, because that's not what the data from the other folks where they've had the ability to crunch the numbers has shown.
I would be willing to entertain the possibility that the individual prosecutor in those jurisdictions is doing a bad job of enforcing the fullest extent of the law in serious violent crime. That could be an alternative reason that very easily could be. All right, I've taken away from your questions. Sorry. I guess I'm calling.
So it's very powerful you mentioned. So I'm familiar with the federal 410 that negotiations around this. And you also said that you waived your own rights to say against it. Is that an actual right that you have, or is that a rhetorical?
Well, no, it's just that when we advise people of their rights, I'm a law enforcement officer, and so we advise people anything you say can and will be used against you in the court of law. And I'm saying I don't have that. Okay. I don't have that while we're sitting here. No, I'm not talking about a statutory common law right to use what they say in a negotiation. I am reassuring them I'm not using what you say in here against you. Fair enough?
What impact do you think mandatory minimums have had on the plea bargaining process? And then do you think there's any reform that's needed there right now?
So there's a good statistical study by Ron Wright that came out in the Penn Law Review. It's about 15 or 20 years old right now, where I think it shows pretty well that the sort of the leverage that that mandatory minimums give in terms of charge bargaining and in terms of just sort of allowing people to calculate an expected punishment really did sort of lead to a pretty major increase in plea bargaining. So I think that's definitely true. I think, look, I'm not a fan of mandatory minimum sentences, except maybe in sort of the absolute most serious cases, you know, intentional homicides, some other stuff like that. I think we have judges for a reason. I think if you're committed to an originalist view of the separation of powers, you would quickly find that the ability to hand out sentences was at least a piece of the judicial power. And we give that power to judges for a reason, because we think that they are neutral in the case and that prosecutors aren't supposed to be neutral, right? It's an adversary system. And what mandatory minimums do is they often give the sentencing power to prosecutors. And if you believe in the Madisonian separation of powers, that should concern you.
So since our criminal justice systems kind of become a system of pleas, where exactly is the reform going to come from? It seems that both of you seem to have at least some qualm with the way that the police system actually is run. So is this something that is going to have to be done by elected prosecutors, the legislature, or are we going to see the courts start running out some new due process or Sixth Amendment jurisprudence? What's our best?
So fun fact, it wouldn't be new due process cases. They would be old pre-Civil War due process cases that never quite made its way all the way up to the US Supreme Court. But a number of state Supreme Courts said that that plea bargaining violated defendants' due process rights. So is that possible? Are they going to do it? I'd be shocked if they did. But judges can make a difference, prosecutors can make a difference, legislators can obviously make a difference. But incremental changes, some of them are, I'm not going to lie, kind of boring. Like, I gave a talk to the National Constitution Center a few months ago, and I was like, here's a boring change that would work. And then my office phone rang 2 days later because a federal district court judge that, one of the last round of appointments that President Trump did on his way out of office, this guy had been a judge in Ohio, a state court judge, and then President Trump picked him to be on the district court. And he was like, oh, I do that. Yeah, that super boring thing that you said in your book, I do that. And I got, he's like, and it matters, right? Defendants make different decisions. Defendants are not pressured into pleading guilty in these misdemeanor cases the same way that they would. It made my day. I was like, that's Judge Calabrese, let's go, let's take this on the road and convince all of these other judges that they should be waiving court appearances for folks who are out and not being detained pre-trial, because the plea bargaining dynamic just looks different in those 13 million misdemeanor cases. It's got wearing people down, sort of the process is the punishment stuff that sort of became in vogue in the 1970s for a reason, like it's real. But yeah, so boring, incremental things, but everyone could pitch in. And frankly, I'll say, I think you guys can pitch in too, right? I don't know about the rest of you. I was the first person in my family to go to law school. I was the first lawyer that they all knew until I got married. I'm married to another lawyer. I'm the only person that they talk to. I get phone calls from my siblings or my cousins because some court case will be mentioned in the news and they want to understand what it means. And I'm happy to explain it. Although I hand the federal jurisdiction questions off to my husband. I was like, oh yeah, standing. No, you should. That wasn't my jam in law school, but he can answer those questions for you. If you guys tell the people in your lives who aren't lawyers about these sorts of things, I think most Americans don't understand that this is what happens. And when one of their loved ones ends up being arrested and gets pressured into taking a plea, when one of their loved ones is a victim of a crime and then they don't have their day in court to tell the story, what actually happens isn't what we think happens. And I think the American people have more power. I think that they have power to change things when they actually care.
And if you want to read more, you can read in Slate from June 16th, 2021 by Coercive and Hessek. If you want to reform the police, get prosecutors on your side. So
it's much shorter than the 370 some odd page report we put out. I'd recommend that.
I agree with that.
Go ahead.
I don't think we heard mention cash bail at all at this point here, and I think it's kind of an elephant in the room in terms of people being pressured to saying yes to a plea because they're sitting in jail because they can't afford a certain amount of money to support the family or whatever it may be. So, at what role does the elimination or the reduction of modification of cash bail potentially play in changing the plea bargain?
So I'd be really interested to hear from Mr. Harder what he thinks about this. My own personal position on pretrial detention is we shouldn't have people have to provide collateral to ensure that they show up again. The best studies on this show that a phone call the night before is much more effective in ensuring that people show up for their next court date than any other intervention that we have. And the question that we should be asking at the moment of pretrial detention is simply whether this person is a true flight risk, not that they might not show up, or whether they pose a danger, and that's actually like it's a pretty small universe of people. And then the question shouldn't be, do you have enough money to get yourself out? It's, should you be released? But I'd be interested to, I mean, I don't have to make those decisions.
Yeah, so I brought my jail list from yesterday with me. So if you want to come down and talk, I'll stick around for a while. And it's public record. So it's got their names, the date of arrest, it's sorted by how long they've been sitting there, what they're charged with, how many active cause numbers they have in my county, whether they're on probation or not. We have 154 inmates. 2 of them are there on misdemeanors. The rest are there on felonies and or probation violations or both. 49 of them have multiple cause numbers pending in just my county, let alone have cases pending in other counties. 35 of the 154 have been sentenced in all of their cases. 30 more have been convicted of a crime and are back for probation violations or home detention violations. I'm actually really proud of the speed with which we're getting these moved. And I know efficiency, we're debating whether that's a good thing or a bad thing, but we're moving through cases and getting to clarity so people aren't lingering pre-trial. And I think that's important if we're going to hold them pre-trial. I'm very content with our bail system that we have. It is, somebody has to think the conduct is out of bounds to report it to police. A police officer has to think this is out of bounds enough to jail this person. I have to agree that what they did creates probable cause sufficient to charge and to recommend a bail. A judge reviews it to say, does this person belong in jail or not? And in Indiana, within days, we're having a bail. Oh, I'm sorry. There's a pretrial risk assessment done. I read talking your book, and I agree with you. The pretrial risk assessment tools are significantly flawed, maybe for opposite reasons, but that I don't know how much value they add. The judge reviews that, makes a decision, and then within days, there's a bail review hearing where we take into account not just whether they can pay the bond, not just whether they're likely to come back. What is their risk of harming other people? What is their risk of committing new crimes while they're out? And we're looking at their criminal history. We're looking at their personal history of failure to appear. We're looking at the facts of that case, which I understand is debatable because of presumption of innocence, but case law is pretty clear. We're allowed to do that. Whether that's a good thing or a bad thing is another question. I don't think what we have here is broken. I also acknowledge I come from a county that is literally 98% white, and so I do not have the same sort of systemic racism issues in my county that a lot of other jurisdictions do. But we're not holding misdemeanors. Nobody's in there on possession of pot. I think we've got the right people there.
One more question.
Oh, you have to arm wrestle.
Oh, yeah. I have a question about, like, it seems like you, Mr. Harder, are like trying really hard to improve the system. A lot of prosecutors aren't under that same obligation. And so is the discretion that prosecutors have an issue in and of itself?
I'm gonna bet you're gonna say no.
Yeah, you can guess my response. One of my first principles is the level of government closest to a problem is the one that ought to be dealing with it. Principle of subsidiarity, also known as federalism, when applied from the federal to the states and locals. It's taught in Catholic teaching. I love the idea that a local prosecutor elected from among the people who is accountable every 4 years gets to impose their judgment on the system, and they get to make those decisions. I don't like how it happens. I hate what Ryan Mears in Marion County is doing to their criminal justice system. I hate it with a burning passion. I hate more the legislature trying to tell Ryan Mears how to enforce the law. They wrote the laws. He gets to enforce the law. If Marion County doesn't like it, they can elect a new prosecutor. I'm a pretty fierce defender of that because I want people to be able to choose their own. And I actually would love to have a longer conversation about how we build in transparency so that voters are making good decisions on that front.
Yeah, so I think I agree with this. I also believe in localism, though I come at it more from a Tocquevillian sort of perspective. My Sunday school teacher would be upset to hear me say that, but I do think that the movement to take discretion away from judges has been problematic because I think multiple actors with discretion is a good idea. But I'd also say that while I personally think that discretion is both inevitable and also necessary, I do think that the legislature could do more to be more specific. So when they pass their laws, more thoughtful when they pass their laws, so that less discretion is necessary. But one of the major things that we try to do at the Prosecutors in Politics Project at UNC is to try to move towards a system where there's a better public understanding about the discretion that prosecutors exercise so that voters can play a role in selecting the local officials that they're most likely to agree with. And unfortunately, that's not the system that we happen to have here. And I really admire Mr. Hartner for, was it an uncontested election in 2018?
It was.
Giving an interview to, I'm just gonna tell you, like, we're gonna have another report coming out to you. This is unusual, like giving not just an interview where he says, I'm running and I'm doing a good job, but the sort of insight into the policies that he's employing that allowed the people in his community to make a decision about whether they agree with him or not. We actually just don't have enough of that. Like, I literally study prosecutors and I don't know what the policies are of my local prosecutor. And when I like corner him and try to ask, like, it's very, we use our best judgment. I'm sure you do, dude, but like, I can't vote based on that. So like, come on. Anyways, you guys have been amazing. Thank you so much. I really appreciate it. And I really, really, really appreciate it.
Thank you very much. Really enjoyed that. Oh, I totally missed the other thing I was supposed to do. If you enjoyed this and still think prosecution is a noble thing that you want to explore, or you want to see how whether it's noble or not, I do an internship program every